On court today, Captain has joined me. I elevated him yesterday. He's looking very dapper this morning. Captain, good morning.
Good morning,
Do you
Lily.
have a date today?
Today, I have a date with you when I'm here.
I like that.
I have a date with you when I'm here. I'm here to honor that date.
Wow.
Yesterday, you elevated me.
Yes.
And I appreciate that because I look forward to that day. But pressure now, no worship.
Anyway, what's up on court this morning?
Yeah, Lily, a lot has been happening. And ever since the issue of our Lady Chief Justice came to the fore and the subsequent suspension, a lot has been happening. The committee has begun its work. In fact, day 5 is already in. The Chief Justice has appeared.
Yesterday the committee sat.
Absolutely.
Okay.
But a lot is happening. Even aside the committee, the traditional courts, actions upon actions, supplementary affidavits, processes, and all of that. We've seen some injunctions already gone by, dismissed, and all of that. But what we do know latest is the fact that the Lady Chief Justice has issued a writ. On top of that, he's asked the court to stop the processes by way of an interlocutory injunction. And on top of the interlocutory injunction, he's also come to add some more additional grounds or additional processes to the court by way of affidavit in opposition. So as you can see on your screens, yesterday, 26th of May, 2025, the Lady Chief Justice went back to the Supreme Court with more processes to add to what she has already filed before the court. And we want to share with you this morning and in that particular supplementary affidavit, Lily, she's been alleging some abuse, infringement of human rights, mental torture by way of the environment, how the whole place is a security zone. She's been having issues with that. But let's share with you the details.
She has issues with the place of hearings?
Yes.
Being a security zone?
Absolutely.
She didn't want a security zone?
That I am unable
because
to...
I'm wondering. That's the only one I'm curious about. That's the only issue because she's the Lady Chief Justice.
Absolutely.
That's
security has to
yes.
be. In fact,
that's you sit on the third arm of government.
Absolutely. And that cannot be taken.
That cannot be taken
so
for
I
granted.
remember the first day that the committee sat on the 15th of May. I was at the venue, and you note that I did not even disclose the exact venue. And I did also indicate the security presence in the area and all of that. And in fact, in the early hours of that day, there were numbers there. But because they did not want to heighten tension in the area, they dispelled all the people there. And then the place was very, very calm and all of that. But the Lady Chief Justice has been saying a lot. She's been saying a lot by way of the supplementary affidavit that was filed yesterday. So as you can see on your screens, supplementary affidavit in support of motion for interlocutory injunction. That is what the Lady Chief Justice, through her lawyers, has filed at the Supreme Court. And this one, she filed it personally. Justice Gertrude Araba Esaba Saki Torkornoo, and she gives the additional information about the fact that she's there. This is coming from the Chief Justice's residence in Accra and make oath. And the oath that she made, she's making the following additional information known to the court. The first that she pointed to or she spoke about was that I am a citizen of Ghana, the Chief Justice of the Republic of Ghana, and deposed to this affidavit on matters within my knowledge, information, and belief. The second point she made is to the effect that on the 21st day of May 2025, I instituted the instant action for reliefs endorsed on the rate of sermon. So the instant action has to do with the main case and the affidavit, the interlocutory injunction. She went on to say that on the same 21st day of May 2025, I filed an application for interlocutory injunction seeking the relief stated on the motion paper. And we have shared that with you earlier. Director, let's move. That I respectfully seek leave of this court. And when you file processes at the court and you want to add more, you have to seek leave of the court, ask the permission of the court to be able to file those processes. So it's a process that happened in court all the time. Seek leave of this honorable court to bring to the court's attention various developments since the filing of the present application, which evidence a complete desecration of my basic constitutional rights to a fair trial, violation of my dignity and subjection to inhuman and degrading treatment. Those are very strong words. Yeah. Of a kind not meted out to even accuse person on trial for treason.
That's quite strong, huh?
That's very. Treason is a constitutional offense.
Yeah.
And that is serious. With the Lady Chief Justice
saying that, for an accused person who's on trial for treason did not go through what she is going through.
But an accused person standing trial, you are as innocent as you and I.
Until proven guilty.
So nobody is supposed to suffer any form of
injustice.
Absolutely. Yeah. Let's move on. And other offenses against the state, okay? That I was informed by my lawyer, Kwabena Edukusi Ekwa, that the proceedings of the committee set up by the president to inquire into the 3 petitions filed against me had been adjourned to a day after the commencement of our action in this honorable court, that is May 22nd May. So we did mention to the fact that on the 15th, when the committee started its work, the Lady Chief Justice was not present. The second time was adjourned to a week later, which is on the 22nd. And she makes the point that 21st, she filed her processes and the committee started on 22nd. She was thinking that once the committee received her processes, which indeed, going forward, you understand that. Director, let's check the next one. Okay, that on the 22nd of May 2025, I appeared before the committee. So that was the very first time that the Lady Chief Justice made an appearance. Right. That was also the committee's second sitting. And we did indicate that the committee was not happy that she missed the very first sitting. Committee, together with my lawyers, and informed the committee members of the suit I had instituted against the Attorney General and the committee members, in response to which the committee requested to receive copies of the processes filed and adjourned proceedings to the following day, that is Friday. Last week, Friday, we told you about the fact that the committee wants to receive and will decide whether to proceed. And after on Friday, the committee started. Even indeed, that was when the hearing started officially by way of witnesses coming in. On 23rd of May 2025, notwithstanding receipt of the processes filed in the Supreme Court, including the application for interlocutory injunction, the members of the committee indicated their resolve to proceed with the conduct of this inquiry or the inquiry. Okay, let's look at the next one. So, despite being informed of the pendency of the interlocutory injunction, the committee said we are continuing with our work. That this was so, even though I have to date not been told the basis for the determination of a prima facie case against me, and the specific allegations in respect of which a prima facie case has been established for me to answer, to enable me determine my legal rights or adequately prepare a defense to the charges against me. So all the argument that they have made in respect of even the other injunctions that have come to the court is to the effect that there are no reasons given to her as to why a prima facie has been established. But that day, one of the justices asked a common question. On the face of it, what's your literal understanding of a prima facie? Don't go into the law and all of that. And I remember the parties in court saying that, yes, on the face of it, without even going into the merits of it, you have to look at it, okay, A, B, C, D. Should somebody answer questions? So you need not to even go into the D. So that is just on the face of looking at the document and all of that. But we will continue with what the Lady Chief Justice has been saying. Said that on the previous adjourned date of the committee sitting on 15th May, that was the first time the committee sat, at which I was represented by counsel, the committee refused to recognize my counsel simply because I was not personally present, and proceeded to fix subsequent hearing dates and makes arrangement for the hearing without involving my counsel, even though he was present. The committee, shockingly, simply refused to recognize the same counsel on whom it had served a hearing notice only a day before. Okay, so those are some of the things that the Lady Chief Justice has stated in her supplementary affidavit for interlocutory injunction. She went on to say that the committee on the said 23rd of May, contrary to known rules regulating proceedings of the commissions of inquiry, indicated that the petitioners shall not give evidence themselves. Wow. So in this case, what she's saying is that the petitioners who petitioned the president for her removal or potential removal, saying that they will not testify themselves. So that brings to
why? Well, I mean,
and he said, but shall be calling other witnesses to give evidence to support their petition. And in law, I know that it happens so many times. There's so many criminal cases that I have seen in court that the accused persons at some point in time would decide that personally I will not testify. Dr. Stephen Kobno-Puni is one of them. The ambulance case, Dr. Kasiel Atoforsin is one of them. And you note that even in the election petition, the second one, against the EC chairperson, when the petitioners closed their case, Jane Mensah decided and said that no, personally I will not speak. And note that the controversy that particular issue brought to the country, but shall not be calling other witnesses to give evidence to support the petition. Okay, so now the petitioner wants to speak through witnesses. So let's look at the other one. Okay, I think now we have missed the step again. Okay, so let's look at the next one, Director. Then we'll hear some of the things that Lady Chief Justice has been making in respect of the surrounding the security zone where the meeting is taking place, the fact that she was being searched and all of that, the fact that her husband, the children were not allowed to be closer to them in all of that. So those are some of the things that the Lady Chief Justice has been saying by way of the injunction or the interlocutory injunction that she has filed at the Supreme Court. But the committee is saying that, yes, we have seen the processes that you have filed at the Supreme Court, but at this particular point in time, the committee will proceed with its work. The committee will not wait for the outcome of the Supreme Court until such time that the Supreme Court issues an express order for the committee to stop its work. For now, what they intend to do is to continue with whatever processes that are before the court and all of that. Let me share more with you, Lily, in respect of what the Lady Chief Justice has been saying in relation to the issues that she has found. And those points are very interesting one, of course. And she also makes the point that if you look at this whole matter, let me point this very well to you. And I think that will sound very interesting. So she makes the point that the other development, like the denial of access into the hearing room for my husband and children, searches on my body, denial of access to telephones and laptops for myself and my lawyers, even though counsel for the petitioners have access to their phones and laptops, and the conduct of the hearing itself in a high security zone at the premises of the castle. Also, you note that so the Chief Justice is giving that information where she is and
exactly,
where the meeting is taking place at this particular point in time. She makes the point that Osu shows a deliberate effort to subject me to mental torture and degrading treatment in violation of my fundamental human rights. She also makes the point that all Article 146 proceedings, with the exception of the one that I am being subjected to, had hitherto been held in a judicial facility, specifically the court complex, the location of proceedings affecting me to be a cordon high security facility boggles the minds. That the persistent violation of my constitutional rights show that the whole proceedings initiated against me are a mockery of justice and a ruse to unjustifiably remove me from office as the Chief Justice. And she concluded by saying that I respectfully pray for this honorable court, as the Supreme Court, intervention by the grant of an interlocutory injunction to prevent the assault on judicial independence and protect the security of the tenure of the Chief Justice and the Superior Court judges. So these are what are contained in the supplementary affidavit filed by the suspended Chief Justice. But Lily, the Office of the Attorney General has been responding by way of affidavit in opposition, but because of time, tomorrow, that will be our main highlight for the day. And tomorrow is the day that the Supreme Court will deal with that particular subject and all of that. So that is it with respect to the latest updates from the Office of the suspended Chief Justice.
What's the latest with regards to the Sky Train? So yesterday I engaged you on Newsroom briefly on that.
The day that you elevated me.
Yes.
So yesterday, Professor Christopher Ameyaw-Akumfi, I mentioned that it was the first time way back in school, secondary school, we've been hearing the name Professor Ameyaw-Akumfi and all of that. Today is the day, yesterday was the day that I got closer. And yesterday she was in court, she was in a wheelchair, suggesting that yes, Professor Ameyaw-Akumfi was not well. She tendered himself in together with his lawyers. His plea was taken in relation to the counts that he was involved in, including willfully causing financial loss. And then the court, presided over by Justice Comfort Asiame, admitted him to bail in the sum of 10 million Ghana cedis with 2 sureties, and the sureties the court are saying all of them should be justified with landed properties registered within the jurisdiction of Accra. Copies of their Ghana card and their digital locations should be made available to authorities. And he, as Professor Christopher Ameyaw-Akumfi, is also to surrender his passport, report to the case investigators once every week, unlike the other accused person who's supposed to report 3 times in a week. And his bail sum was 15 million Ghana cedis with sureties and all of that. And we're told that he's 80 years of old. So yesterday he appeared, his plea was taken, and then granted bail in relation to the Sky Train. $2 million alleged financial loss to the state.
To the state.
Absolutely.
Was Kwabena Dubois in court yesterday?
So for the first time, his lawyers led by Samuel Atachia indicated to the court that all the accused persons are on bail, and they are on bail, so they came directly from home. So there's no issue about the national security Yoko picking up anybody. All of them are on bail. And yesterday, an interesting development came to the court when the court has to make an order. But before the court made an order, prosecution indicated to the court, explained to the court circumstances leading to it not able to comply with an order to file their disclosure document, witness statement, and all of that. So what the court did was that it said one of their key investigators is indisposed, and they needed him to sign portions of the processes before it is filed. And they hope that by Friday he will be in. Then at the end, they approached the bench. Even before the whole thing started, they approached the bench before Justice John Eugene Nyantenyedu asked of the business of the day, where the Deputy Attorney General, Dr. Justice Tremsai, informed the court about the challenge they had by way of not filing the process and requested for a short date. Lawyers for Kwabena Dubois and the wife, the other accused person, did not oppose to that. They make reference to Article 88, which gives the Attorney General the power to initiate and conduct criminal matters and all of that. They said, we will not stop them, we will not stand in their way. Then the court made an order for the AG to file the witness statement by June 2nd. Then the case was adjourned to June 11. But before adjourning the case to June 11, the court said the court is making an order that no pre-bargaining agreement will be initiated until such time that the accused persons receive all disclosure document from the Office of the Attorney General. Then we were curious to find out, has any of the parties start to negotiate? Or in this case, before you start a plea bargaining, it is the accused person who will have to go approach the Attorney General and say that we want a plea bargaining. We are coming with a proposal to pay the money, or this is our proposal, so that at the end, they in exchange for a lesser punishment. But all the parties have been denying that. We spoke to Samuel Atachia moments after the court sitting. We've been asking him, have you approached the AG for plea bargaining processes?
Now, there's nothing on the table for us to play bargain.
What do you make of the delay of the prosecution in filing the disclosures as of now?
I'm not too sure. Maybe the issue will be with the Attorney General. Let's give him the space to prosecute the case. And let's respect the fact that if an Attorney General wants an adjournment, then we shouldn't challenge it.
Also, it's curious that the judge would make the case about plea bargaining if neither the AG, the prosecution, or yourself.
Because it's a variable. It's a variable in the case management process. Yeah, it's a variable. So he's thinking elastic, but we've not made any overtures relating to plea bargaining.
Is it because you have not seen the volume of evidence against your client by way of prosecution or filing disclosure processes?
It's out of the way for one measure, and we keep saying that people do not understand, and I don't want to do a media trial. That this case has national security ramifications.
The last time we were in court, your client had been kept in bail because, on remand because of a separate case, the Ghana Water Limited. Have you so far been briefed? What is the issue with that?
Well, it's also gotten to do with Ghana Water Company Limited seeking help from national security, give them all the surveillance and the mechanism so that we could police the sanctity of water in the realm. So that's another national security matter.
So nothing wrong by your client there?
Well, at the moment it's very innocent by the terms of the Constitution, and to prove it otherwise. But what is happening now, I'm afraid people don't understand. It's deeper than what is being presented.
So that is Samuel Atachia, who is counsel for Kwabena Idubuahin, Angela Eji-Boateng, Major Donko, and of course Advantage Solutions, the company in the mix of all of that. He said there's nothing on the table by way of plea bargaining. But one of the things that also work in relation to this is the fact that before case management conference, all of these issues will have to come to the table for consideration. But it looks possible that probably somebody somewhere is thinking about plea bargaining in respect of this. But we'll keep monitoring that, and then in our subsequent appearance and updates, once we have anything to show. So that is the Deputy Attorney General, Dr. Jesse Shremsai, entering the court yesterday when the matter came up. So that's all we have for you by way of court today. But you expect some updates on the Attorney General's affidavit in opposition to the Chief Justice's interlocutory injunction. That will come up at the Supreme Court tomorrow.
All right, Captain, thank you very much. So that's Murtala Inusah. He's our legal affairs correspondent with court today.